All right, we're going to get started. My name is Steve Lorberbaum, and welcome to this month's edition of What's Your Plan? I'm your host at Assisting Hands Home Care. We, on a monthly basis, try to have an industry expert come talk to us about a variety of topics involved with aging. The goal of this is to help educate people about the things they need to know as they age. Whether they choose to age at home or they choose to move to a community, we want to make sure they have the knowledge and the resources. So we have a YouTube page where we probably have about 20, because we've been doing this for a couple of years, 20 different What's Your Plans on a variety of topics. So if you're interested, I encourage you to go out to our YouTube page and see who else we have. But today, we're very lucky. We have Megan Campbell. She's with the Willow Legal Group, and she's going to talk to us about estate planning and all things required to plan to make sure that you handle things right and you're not dumping a pile of stuff on your loved ones after you're gone. So Megan, welcome. Just introduce yourself briefly and give us a little bit about you.
Yeah, thanks, Steve. Thanks for having me here. I'm Megan Campbell with Willow Legal Group. This is my family, and I always point them out because really estate planning, you spend a lot of time talking about yourself, but the gift that you give with an estate plan is planning for your family and ensuring that things are taken care of for them. Go to the next slide, please, Steve. So I spent the first 14 years of my career working in-house in a corporation and really made a pivot over COVID to do estate planning after doing pro bono estate planning for many years. And I love working with families and helping them figure out what their plan is, what makes the most sense for them and their family, and how they can pass on a legacy of care and ease for the ones that they love the most.
Great. And so a little bit about me. I'm the owner of Assisting Hands Home Care. We're a private duty home care company. We work all over Montgomery County, PG County, and Fairfax County, Virginia. And what we basically do is help people wherever they need help, whether it be at a private residence, an apartment building, a hospital, a hotel, an independent living community, or an assisted living community. If people need a little extra help, both with personal care activities or just with shopping or errands, that's what we do. So, but today it's really all about Megan. So we're gonna jump right in, and Megan, tell us basically, kind of what's estate planning. What does that actually mean?
Yeah, so estate planning is making a plan to handle situations in which you're incapacitated. So you're in the hospital or unable to make decisions for yourself. And then when you've passed away and what happens to all the things you own and all the people you love when you've passed away.
So when's a good time to do an estate plan? Is there a time where it's too late? It's too early?
Yeah, it's never too late. And really we tell folks that once you're 18, once you're an adult, you need some sort of plan in place. Because at 18, right, your parents no longer take over for you, can't make medical, financial, legal decisions. So you at least need a basic plan then. Once you have kids is another time to consider planning because you need to name guardians for those children. We often see folks come back in when their children have grown, right, and they're empty nesters, and their children are now able to help them make decisions. It's best to look at your estate plan every 3 years so that, as your life changes, your estate plan changes and there are no surprises and it can keep up with you.
So what are the basic documents in an estate plan? Like, I know everyone knows about a will, but what else would you view as an essential document to have as part of an estate plan?
Yeah. So in addition to a will, you need healthcare directives, so advanced healthcare directives and living wills, which direct who can make medical decisions on your behalf and what your wishes are at an end of life situation. And then you need powers of attorney for financial and legal decisions. So naming people who could step in and make financial decisions on your behalf, or any legal decision, taking care of paying your rent and paying or mortgage or paying bills in the case you were in the hospital or otherwise couldn't take care of those things.
Okay, so it sounds like there's 4 or 5 documents. There's a will, there's the advance directives, which talk about how you want to be treated. There's a medical power of attorney and a financial power of attorney.
Correct.
Okay. Anything else that you would recommend that should be considered when someone's thinking about all of this?
Yeah, when you're looking at estate planning and talking to an estate planning attorney, really looking at what document makes sense for passing on your assets, whether that's a will or a trust, and understanding how the probate process works, how the, what that means for your family, and making the best decision for you and your family. There isn't, a will's not particularly better in one situation or another. Same with the trust. It really depends on what makes the most sense for you and your family.
Okay, so I realize maybe this is a hard question to answer, but I hear a lot about, people having trust as part of their wills, and they're either revocable or irrevocable. What does that all mean?
Yeah. So a revocable trust is a trust where that you control what's in it. You take things in, out, you can make changes during your lifetime. An irrevocable trust is a trust in which you have given up control of assets, and you've said for, a number of different reasons, I'm not going to control these assets. I'm going to let, my brother or a person I've named control the assets. And the advantage of an irrevocable trust is to take assets out of your estate, or in a nursing home situation and planning for Medicaid, taking those assets out of consideration for the assets that you have to pay for nursing home care.
Gotcha. And so I don't want to get too far off track. So you mentioned something very important, Medicaid planning. Is that something you do? And can you explain what that means?
Yes. So that is something that we can help with. And what that means is, the cost of nursing home care in this area is $10,000 to $12,000 a month, right? So it's quite a large sum. And if you haven't done planning before, right, through long-term care insurance, or, or don't have lots of assets saved, folks sometimes need to look at planning for using Medicaid and ensuring that if they have one spouse that needs nursing home care and one spouse who is still able to stay at home and live in the community, how do they provide that nursing home care for the spouse who needs it without completely, bankrupting the spouse in the community? And we can do planning around that and help protect assets to ensure that the spouse in the community has the resources they need, while the spouse in nursing home care is able to receive that care without spending down all the family's money.
Okay, so I've heard things about like look back periods and all. What does that mean?
Yeah, so the government will look back for a 5-year period to see, right, if you've given away money. They don't want you to say, oh my gosh, I need nursing home care. I'm going to give everything to my kids and have no money and then need to apply for Medicaid, right? So the government will say, we're going to look back and see what you've done over the past 5-year period. And then if you've given away money or moved assets during that period, there is a penalty period before you can receive Medicaid.
Okay, so we have a number of clients who are in their 80s or 90s, and they have an adult child with disabilities that may be living with them. And their apparent plan was going to be to live forever. And it's unlikely that that's going to be a successful plan. Do you assist with special needs planning and other things that might give people peace of mind to set their adult child up for success after they've gone?
Yes, so we can help set up special needs trusts, which what a special needs trust does is it will help protect assets and protect that special needs child from losing any benefits that they have. If they have income related benefits from the government, if they receive an inheritance, right, from their parents, they could lose those government benefits. So their parents are able to set up a special needs trust, which then is not counted for those government benefits for the disabled child, and still allows the parents or the trustees in that case to provide those additional needs and things that that child may need long term.
Okay, and do you help people with the planning for this kind of thing, and whether or not they might need a family trustee or a professional trustee? And do you have relationships that if somebody needed a professional trustee, you could recommend?
Yes. So what we do with families is we sit down and look at everything and talk through all your options, and then help you connect with resources that would make the most sense for your families.
And so how do you counsel families on having the conversation, right? I know, we have, again, lots of clients who they've never talked to their children, their adult children who are in their 60s, about the fact that one day they might not be around and kind of what they want. How do you help people through that?
Yeah.
Or do you?
Well, so that is probably one of the hardest conversations to have, right? I think it's hard for everyone because we all think that or hope that we're going to live forever. So one of the things we do include when we do planning for folks is we include a family meeting, and we will help, get everyone together to talk through the documents. And really, we approach it as this is a gift that you are giving your family, right? When you can talk about it now and you can help answer questions and really express your wishes, that then when your family members need to use those documents, especially in healthcare situations, they aren't second guessing the decisions that they've made, right? They know you've had that conversation and they know what you would want. So when they make decisions, they don't have to second guess or potentially feel some guilt around whatever decision they finally made, saying, oh, is that something mom really wanted? Is that what dad really wanted?
Well, and as part of your process, do you involve adult children in the discussion for what the will and directive should look like? Or is that something you do just with the person who's signing the documents and it's up to them to do it afterwards?
It depends on what the clients want, right? So if our clients want us to have a conversation with their adult children, then we will, and we'll help this, have a conversation in whatever way makes the most sense for the client and is the most comfortable for the client. There is some one-on-one, right, discussions with the clients just to protect the confidentiality and to ensure that those wishes are really the client's wishes and not other family members.
Okay, and so how do you work with families? Let's say, we'll get to how do we find you, but let's say we found you. What's the next step? What do you do?
So the first step is we sit down and we ask you to fill out some information about either what your current estate plan is, or if you don't have any plans in place, what your goals and wishes are and how do things, what are your financial assets and all of that. So we can sit down in a discovery session and have a conversation about what would happen now. How do your current plans work? What, if you don't have a plan, what is Maryland's plan for you? And what does that look like for you? And what does that look like from your family? And so then you're able to tell us, oh, I don't like that, or this concerns me. I, want to avoid this. And then we can create a plan from there.
Okay, so can you explain, hopefully you can, what a MOLST form is, and how does that compare and contrast to an advance directive? Do you need one? Do you need both? What are they for? Why are there different things?
Yeah, so the MOLST form comes in a do not resuscitate, like end of life decisions and how you want your end of life. And Maryland has a number of different options out there for advanced healthcare directives and MOLST and how you want your end of life decisions, and medical powers of attorney out there. There's a state advanced directive that you can fill out that includes the names of your agents, that includes end of life decisions. There's the MOLS form. There is like 5 wishes is also another advanced directive type form that I've seen clients use. Unless you have a family member who has access to that safe deposit box, when your family needs them, they aren't going to be able to access them. Really, what you should do is give copies to those people that need it, right? Ensure that your physicians have copies of it if you think they would need it, but provide a copy to your healthcare agents. And that's a great time to have that conversation. Say, I've named you, as this person, these are my wishes. I'd love to sit down and talk about them. So, if you have any questions, I can answer them for you.
And tape it to the side of the refrigerator. So because EMS, when they rolls up to someone's house, they will look there.
It makes a lot of sense.
Okay.
It makes a lot of sense. And I've actually provided for clients who have lived in assisted living and have folders on the back of their door. We've provided them with copies for there, as well as a list of the people who need to be, loved ones who need to be called, folks that are agents. So it's very obvious and clear as to who are the people that need to be informed and who are the people that can make decisions.
Gotcha. So let's go to the bad side. Let's say, you haven't done any of these documents. So you don't have a will, you don't have a medical power of attorney, you don't have a financial power of attorney, but you do have dementia. What happens to you?
Yeah. It really depends on what stage, right, of dementia you're in. If you are able to make decisions on your behalf. If you can't make decisions at all, then the next step is a court-appointed guardian.
For what?
For someone to be able to make those decisions on your behalf.
So financial and medical.
Financial and healthcare decisions, yes.
Okay. And so let's say I don't have a will or a medical power of attorney, but I have a daughter. Does she get the right? Does the law or does something presume that absent a document, she has the authority to make decisions on my behalf? Or is it, you're out of luck and the court's going to come in and figure this all out?
So, the way I've seen it is that it really depends on the institution that is making decisions, not financial institutions, right? But healthcare providers will often defer to a spouse, will defer to an adult child. In that instance, right, especially for financial decisions, the court will look at the best options, right?
Is there any law on this or common law that provides guidance that people who, don't have something in place can know that there's at least some framework, or you're just left to whatever a hospital or rehab decides?
So the court will look, right, first towards spouses and then towards adult children. And if none of those people are willing to act, they will bring in a third party that is trained in making these decisions.
Okay. So, but if I'm in the hospital and I can't make a decision about some surgery, but my daughter wants me to have the surgery, will I be able to get that surgery? Even though I can't answer?
Yeah, hospitals tend to defer to spouses and then adult children.
Gotcha. Okay. So I guess it then becomes a problem when son one thinks the surgery should happen, but daughter one
Correct.
doesn't want it.
Or, right, if maybe your adult child isn't the person you want to be making decisions for you, right? You have very different views on medical procedures, end of life, any of that, and that's not the person that you want to make decisions. So not having directives in place, not having people that you've named, opens up the possibility that what you would want is not always followed.
Gotcha. And so what happens on the will side? Let's say I don't have a will and I die. Is there some state mandated framework, or is it just a free for all with all my kin filing lawsuits against each other?
Yeah, it's not a Hunger Games type of situation, right? In which your family fights it out. Maryland does have a plan for anyone that doesn't have a will. It's called an intestate. And what happens is it will go to your spouse and to your children. If 50% to your spouse, the remaining to your children. If your spouse is passed, then it will get divided amongst your children, and the court will then look, if you don't have any living children, go down the family tree. One of the things that I see happening sometimes is folks that have been separated and they've not officially gotten divorced, but they've been separated for a period of time. Your spouse still has claim to that, to their inheritance from you.
Gotcha. And are there any laws now that would protect same-sex couples, whether they're married or not? Or is that something that if you're a same-sex couple, you really need to do this?
So, the state of laws around that is in flux. Before, maybe a year ago, I would have said no problem. Same-sex marriage has been wildly recognized, and you can move forward. But given the political climate of the past couple of years, our advice is always to ensure that if you are in a domestic partnership or are same-sex couples, to ensure you have these documents in place.
Gotcha. So if I've been living with my partner, male or female, for 15 years, and that partner ends up in the hospital isn't necessarily going to presume that I have the right to speak on behalf of that person.
Correct.
Okay. So the moral is get some documents.
Yes.
Okay. And what's the process? Does it take a long time? Is this like weeks of like hand wrenching and soul searching and document crafting, or can this be a relatively simple and painless process?
We try to make it as simple and painless as possible for folks, because we know it's something that can seem overwhelming, and there can be lots of decisions and you don't know what to do. So after that discovery meeting, that's really where we decide what's best for you and your family. And about 4 weeks after that, we'll have everything prepared and ready for signing. One of the things that we do adds a little time on that is we'll take everything back for you and scan it and give you not only, hard copies of your documents, the ones that you physically sign, but give you an electronic copy so that you're able to save those documents securely, share them with the folks that you've appointed.
So let's say I'm in my early 90s and I really can't leave the house. I don't want to get this done. Can you come to me and help me get my documents signed and all the things I need to do to get a packet in place?
Yes, we will come to you. We offer, Zoom and virtual appointments. If that, technology doesn't work, it's not your strength, we're happy to meet you at your home, to have those initial meetings, come back and do the signing at your home, bring your binder and all your documents to you once they're ready for delivery.
Okay, so if I live in an assisted living community, you can still help me out.
Definitely.
Gotcha. Okay. And sort of, and I don't want to put you on the spot, but kind of what's this cost? How do lawyers, or how do you, I don't know, I don't know lawyers, but how does Willow Law Group charge for this kind of service?
Yeah, so we charge everything on a flat fee basis because we want to ensure that clients feel comfortable asking questions. I've been on the client side of legal work a number of times, and it is the most frustrating thing to have a quick question, call your attorney and ask your question, and then receive an invoice in the mail for a couple $100. You go, oh, but that was just a 10-minute question. And so the next time you have a question, you go, oh, is this a $100 question? Is this a $150 question? And you don't know. And we don't want folks to have that worry, right? We want you to have your questions answered and ensure that you're comfortable with your plans. So we agree on a fee up front after that discovery session. It ranges from $2,000 for a basic will plan, which includes all of those documents we discussed before, up to $5,000 for revocable trust plans.
Gotcha. Okay. So we only have a couple of minutes left. If anybody has any questions, either you can certainly type it in the chat or take yourself off mute and feel free to ask away. I'm not sure I asked everything that people want to know about, but we're happy to help out. So we'll see. So all people, yeah. Sonia, what you have?
Yeah, so you said you work with people in our, assisted living. I know you're in Rockville, right?
Mm-hmm.
What is your range of working with people? Is it Montgomery County?
Yeah, so Montgomery County and Frederick County will also go into Howard County. But if you have somewhere, we service Maryland and are happy to kind of discuss what makes the most sense.
So Willow Law Group is licensed only in Maryland. Do you do work in DC or Virginia or no?
We don't, but we do have great referral partners that work similarly to the way that we do in DC and Virginia.
Gotcha. Okay. Anybody else with questions before I wrap up? All right. Well, thank you all. If anyone wants to talk more to Megan, you have her contact information listed below. It's hello@willowlegalgroup.com. Phone number 240-813-8843. If you want to talk to Assisting Hands about home care options or just other resources that might be available, you can reach Patricia DeBroof or me, Steve Lorberbaum, at 301-363-2580. And again, thank you all for joining this month's version of What's Your Plan. We really appreciate your time, Megan, and we look forward to seeing you all again at next month's What's Your Plan. Thanks very much, and have a great rest of the day.
Thanks.